What are the employer's legal obligations under the ADA once they find out a worker is disabled? Once an employee becomes disabled, okay, HR is required to participate with the disabled worker in the interactive process. More specifically, the interactive process is essentially a good faith conversation between the disabled employee and HR. And the whole point of this ongoing conversation is to find a reasonable accommodation for the employee so he or she can perform the essential functions of the job. This conversation can be in person, can be over the phone, or preferably it can be entirely in writing via email. Once the employee requests an accommodation, or the employer becomes aware that the employee has a disability and an accommodation might be needed, the employer is legally obligated to initiate this interactive process. Moreover, the interactive process is a continuing duty that is not exhausted by just one effort. It's an ongoing process because most medical conditions and most jobs are not static. They change rapidly, right? So, okay, what is discussed in this interactive process? Well, essentially, the employer is obligated to do 4 things during the interactive process. Number 1, they need to determine, or they need to analyze the particular job involved and determine its essential functions. Number 2, they need to consult with the disabled worker to learn his or her precise job-related limitations and how a reasonable accommodation could overcome those limitations. Number 3, the employer is required to identify any potential accommodations and assess their effectiveness in helping the individual employee in performing the essential functions of the job. And number 4, the employer is required to consider the individual's preference and select and implement an accommodation most appropriate for both the employee and the employer. Now, the thing that companies should know is that the law is very clear. An employer fails to engage in the interactive process as a matter of law if the company rejects the employee's proposed accommodation and offers no practical alternatives. The employer must participate in the interactive process in good faith. Now, if the interactive process breaks down, the court is going to attempt to find the cause and assign responsibility. For example, often the cause of the breakdown is missing information. When the missing information can be provided by only one of the parties, the party withholding the information is probably going to lose. A good example of this, and one that's very common that I see, is if the employer requests a doctor's note outlining the employee's limitations, and the employee never gives that doctor's note to the employer or to HR, that would be the employee's fault, and the employer will likely be found not liable for failure to provide an accommodation. The short clip you just watched was taken from my complete video called "The Shady Ways HR Refuses to Accommodate Employees." If this information was applicable to you, I strongly recommend that you watch the original video in full to gain a complete understanding of my meaning and context. There's a link in the description and a legal disclaimer at the end. As you probably know by now, I'm a California lawyer. If you worked in California and you got fired from your job and you think something unlawful happened, don't be afraid to pick up the phone and give my office a call for a free consultation. Thank you for watching and have a great day.